We're
Well,
away.
hello, and welcome to the latest of Practico's Cost Chat Between Friends. The friends start with the usual suspects of myself, Jeremy Morgan, retired costs barrister and consultant to Practico, and Andy Ellis, the managing director of Practico. And our guest this time, another old friend, is Roger Mallalieu QC, who needs no introduction, is the usual thing that one says in these cases, but he's fresh from a victory in the Supreme Court, which I was pleased to see. But the other thing I was pleased to see about Roger and his chambers is that they have elected Nicholas Bacon as head of chambers, which is certainly a step forward for Costs Council. It used to be regarded, Cinderella would actually be rather polite for how we were generally regarded. But big step forward for a major set to elect a cost barrister as their head of chambers. So congratulations to Nick and to everyone in 4 New Square for that excellent decision. Moving on to what we're going to talk about. There's not been a huge amount in terms of interesting decisions to report to you. So we thought we'd have a chat on more general themes. The first is the dreaded Solicitors Act. Does the Solicitors Act need reform, and if so, in what direction might that reform go? The next topic was going to be the extension proposed by the government of fixed recoverable costs beyond the existing limits and beyond the existing cases. The third thing was DBAs. Are we seeing more of them now? And is that a good thing? A very brief touch possibly on the recent CJC consultation on the pre-action protocols, where there's a mention of costs, which we'll just touch on, but it's very briefly mentioned there. And finally, we might, if we've got time, look at the effect of opening up post-pandemic, if indeed there is opening up, because I see that new restrictions are being imposed in the UK. I speak from Italy, where we've been living with restrictions for some time now. But with that brief introduction, over to you, Roger.
Oh, morning, Jeremy. Morning, Andy. Thanks for that introduction. Yes, well, I mean, if we're starting with the Solicitors Act, then I think anybody who's heard me talk on this before probably is well aware that I take the view that it's past its best, long way past its best, and doesn't really serve a proper function, whether it's for solicitors or consumers or clients, whatever we're going to call them, and that it's long overdue for reform.
That's it.
That's I mean, that's the headline. In terms of why, I think we only need to look at the cases to see why. It seems to me to be, frankly, faintly ridiculous that the main piece of legislation that's meant to govern the relationship between solicitors and their clients spends all its time in the appellate court with people just trying to work out what it means. Not in court with people getting remedies or arguing about what the remedies are, but arguing about whether something is or isn't a statute bill, arguing about what the effect is of the time limits, arguing, I mean, we've got cases coming up in the Court of Appeal next year about Section 74 of the Act and what it actually means. I mean, that we're still here, although the Act notionally is, what, nearly 50 years old, in practice, the similar provisions have been there for over 100 years. And yet we're still here just trying to work out what it actually means, with both solicitors and clients spending huge sums of money arguing about legal technicalities, which is wonderful for people like me and Cost Council to be arguing these interesting points of black letter law. But I struggle to see that it's in the interests of either the solicitors or the clients, really.
If I can be devil's advocate, because I'd love the Solicitors Act cases when I was in practice. And I noticed I hadn't remembered that the first law on the subject, the first statute on the subject, went back to 1729. So that's nearly 300 years ago. And it's basically the same format as you have now. So, yeah, there might be something in what Roger says. But there is an issue, isn't there, with solicitors? Because if you abolished the entire machinery, you'd end up with a system where a solicitor sends in a bill to say, I've done so much work at so many hours at such and such a rate. and you've got to pay me that. And the court would then not be in a position to assess the reasonableness of the hourly rates because they would be fixed by contract and be very hard to go behind those. And on the question of hours would struggle a bit to look into the amount of time spent. And most judges would probably not want to do that and would just say, well, that's what the solicitors billed. And there would be a heavy burden on the client somehow to show that the solicitor had acted unreasonably. So isn't there a case for at least some mechanism whereby an independent authority looks particularly at hours spent, because that is a difficult issue, and possibly also rates charged, before a solicitor can get a judgment in his or her favour?
Yeah, well, I can see some force in that point for the reasons that you give. I mean, that said, of course, there are other professions where there's a not dissimilar relationship between clients and professionals, accountants, for example, where there's not perceived to be the same need. Well, some might say there is the same need, of course, because anybody who's ever been involved, as I have, in disputes about accountants' fees may say there is exactly that same need, but there just isn't the similar solution proposed. I mean, there are, of course, a whole range. We have much better general consumer protection legislation now than we did at the time of the Solicitors Act. And indeed, of course, that's one of the overlaps. I mean, we now see in a lot of these solicitor client cases, we see, for example, the Consumer Rights Act being thrown in there, and these sort of points. So there's much better general consumer protection legislation. I can see the point that there may still be a need, because of the peculiar relationship between solicitors and clients, for some mechanism which allows clients, particularly lay consumer clients, to challenge the core fees that the solicitor's charging. But if that is right, if we accept that point, I think it needs to be simpler, much more easy to operate in practice. And for example, the whole issue about statute billing, I mean, why we have this complicated system whereby, frankly, in my experience, half the time, not even the solicitors, let alone the clients, properly understand whether the bills they've sent satisfy the requirements to be a bill which triggers the time limits under the Act. Surely there must be a simpler system. For example, and again, just playing devil's advocate, you could simply get rid of the whole idea of interim statute bills. You could say it's simply not possible to have a statute bill during the lifetime of a case. You can't trigger the time limits until the case gets to the end. In one stroke, that would remove a significant element of the uncertainty and the confusion that exists. Or if you were to go the other way, you could simplify the process and have a simple set of rules set out in the statute or a regulation, which gave a sort of simple tick box set of criteria as to what you had to do to satisfy the requirements, and that those boxes were either ticked or they weren't. So I can see the point that we may still need some kind of legislation of that kind, but I still maintain my position that what we have isn't fit for that purpose.
I don't think there'd be too many people who disagree with you about that, Roger, but particularly in relation to the statute bill point, because it's an impossible situation. And I think there's a lot to be said for saying, well, you know, the statute bill is the bill that comes at the end of the day. Yeah. And the problem for that is solicitors can't be sure of banking, if you like, all their interim bills. But, you know, with a certain amount of prudence, they should be able to work out how much they can bank and how much they can't. And they shouldn't then face the problem of the bill being completely invalid, because that's the real problem. Yeah. You know, you end up with a bill which is declared for one reason or another to be invalid, and you've banked all the money and you've got to pay it back.
Yeah. No, and of course, that's a less than ideal situation again for everybody. It's a nightmare for the solicitor, but it's also not great for the client, because of course it means the client at that point still doesn't know what they're actually going to be billed for that case. And I'm sure we've all seen cases, I have, where actually solicitors have been able, because they were told their bill wasn't a statute bill, to go back, rake through the whip and present a bill at the end that's actually more than the bill they originally presented. So it's a nightmare situation for everybody involved.
Yeah. What about your take on it, Andy?
Well, I share a sense of a slight sense of unfairness, you know, on behalf of solicitors relative to other professions who don't seem to have the same the same obstacles put in front of them if the reasonableness of their charges are ever challenged. And I do think that, you know, going back to some of the old law, I mean, the whole idea that you could that large elements of bills could be struck out on a Solicitors Act assessment because unpaid disbursements were not marked as unpaid, or something as arcane as that, is utterly mad. And that type of thing has got to go. But I haven't got an answer to the interim and final statute bill, because if a case is running on for 4 years, what do you do? You know, if you really got to wait until the end before and then be subject to challenge over 4 years for costs that everybody's forgotten about as you go along. Contrast that with bills every month that don't necessarily reveal a potential, not so much overcharging, but unreasonable charges, because even the tasks or phases that you're involved with haven't come to an end. Likewise, starting challenges on bills before you've even finished the instructions seems to me to be a disaster from a client relations point of view. And if that's the road that clients are pushed down, then you can understand why this thing's terrible. I think it's really good of Roger to volunteer to put it all right. I think as his guy.
Yes, indeed.
I'm never going
to
to do that, because we were so popular when we thought that we should get bills put into Excel, that I think I'm not ready for another reform consultation or anything anywhere near it. I'm going to sit back and watch everybody else do it.
Well, having seen the fight that you got, and of course our good friend Alex Hutton for putting his name to the report, I don't think I'm going to be putting my head over the parapet and volunteering for a Mallalieu report, even if I was.
No, we've only just come out of our safe houses actually from that.
I think that's chicken of you, Roger. I think you should definitely be up for it.
Well, it's definitely a hobby horse of mine anyway. And I know I was interested to see that at the there was the Cost Law Reports conference. Andrew Gordon-Saker, the senior cost judge, was on shortly after I'd done one of my rants, as they're known, about the Solicitors Act, and he'd missed that, thankfully. But he popped up, and his starting theme was he thought the Solicitors Act was long overdue for reform. So I think it's a view that's fairly widely shared. The question is just whether there'll ever be any sort of government interest in doing something about it.
Yeah, no, I think that must be right. Moving on then to fixed recoverable costs, we have Jackson 2 or Jackson 3's recommendations in relation to that, which have been partly accepted by the government, but not wholly. And we wait to see what's going to come about. I think a big contentious area is exclusions from the scheme. What's your thoughts on that, Roger?
Yes, well, I mean, it's coming, as far as I can see. Having done quite a few cases in this area, the judiciary likes the concept of fixed recoverable costs. I think some practitioners like it. If they can make models work well, then I think they can be reasonably successful. From a sort of cost lawyer's perspective, the big issue is always, whenever you have any exclusions or exceptions, they are the big battleground, and the more you have of those, the greater the desire on both sides to take advantage of those. The defendants want to prevent anything falling into the exclusions. The claimants want to rely on the exclusions. And in terms of the proposals coming forward, I'm sure we all know the basic outline of them. But again, it looks as though the way it's phrased, we're going to have similar exclusions. We're going to have probably some sort of test of exceptionality. We're going to have different categories which are excluded. You're going to have issues about value, and all of that is, of course, just going to create a further battleground, I think, for people to argue about.
One of Jackson's categories was cases where there are particular reasons to assign to what he designated as the intermediate track that would now be the the relevant part of this existing track. That did seem to me to be creating a fantastic battleground in terms of what should be in and what should be out, unless it was very carefully defined.
Yeah, and there'll be you can imagine that CMCs, case management conferences, turning into a huge battleground as to what allocation you're going to have if all fast track cases are going to be in fixed costs, and what is and what isn't a simple intermediate case. And of course, there are ongoing arguments at the moment about some of the existing exceptions, such as what is and what isn't a clinical negligence case. And if clin neg is going to be brought into fixed recoverable costs, then again, there are going to have to be very careful definitions as to what actually, it may seem obvious, but what actually is and what isn't a clinical negligence case.
Yes, I think you mentioned in our previous chat the hair laser removal of hair. Is that clin neg or is it not?
Yeah, cosmetic treatments, but there are other ones, care homes, aspects of treatment in care homes, these sort of things. That there are quite a lot of cases going on there at the moment, and at the moment the existing definition of clinical negligence really doesn't say any more than it's a personal injury in a clinical context. But then that just begs the question of what that means. Yeah.
But although that's where the exclusions are, and that I suppose is where our focus as people at the front line tends to be, there must be quite a good argument for it being a good thing that a number of areas of costs are just taken out of the everyday assessment process.
Yeah, well, I think so, and it's certainly, I think it's probably a more effective way to try and deal with the perils and difficulties of detailed assessment than cost budgeting has been. And of course, fixed recoverable costs has notoriously been used on a few occasions as sort of the big stick to warn people that if budgeting didn't work and they didn't start behaving themselves on costs, then fixed costs was coming down the line. But I suspect it will probably be much more effective at removing the assessment type of satellite cost litigation than budgeting ever has been. Of course, and again, the devil with these things is always in the detail. What are the figures going to be? And of course, the other issue with the figures is once the figures are set, are they going to be properly updated? Because again, even if people can live with the figures once they first come in, as we've seen, time passes, and if these things aren't updated, then of course it creates a further set of problems. But in principle, I think fixed recoverable costs is a good idea in certain areas.
Okay. Of more interest to probably commercial clients who are watching now, DBAs obviously started off with a huge amount of difficulty, very slow to take off, all sorts of concerns about them. How would you assess the field at the moment?
Yeah, well, just speaking from a practical level, up until the start of this year, DBAs were not being very widely used at all in my experience. I'd been asked to do a few, and I think the ones that we were asked to do, people were sort of approaching on a risk basis, if I can put it that way. They knew they were taking a risk, but on some occasions the potential reward was so significant that it was a risk that was perceived as being worth taking. But for most people, those risks were too significant to regularly use a DBA. And then, of course, we had Lexlaw, the Lexlaw and Zaberi case, and things have changed. And from my experience, things have changed quite significantly. People are much more willing to use DBAs. I've had a lot more queries about DBAs and drafting of DBAs. I'm aware of firms that have set up funding arrangements with third-party funders tied to the use of DBAs, which they're promoting quite heavily to clients. So I think this year has been a real sea change in my experience for the use of DBAs. Still not perfect by any means. It would be great if the government took the hard work that Nick Bacon and Rachel Mulheron had done and actually used that. I mean, the work's all been done for them. But certainly much better and much more widely used in my experience.
And have you been involved, or is it really too far up the track for you?
Yeah, a bit early, because we don't typically get involved in the same way that Roger does with being asked to draft DBAs, and we do try and sort of slip the shoulder a little bit if something comes along that way. But yes, well, unless something's going to be involved with DBAs and budgeting, then that's about the earliest we would hear about them. So they would be later down the line. But yes, I certainly got the distinct impression that there was definitely an appetite for DBAs, and there's a desire in the right case for law firms to want to take them on, and they're sort of petrified of falling foul of technical issues and non-recovery, and quite right too. So if Lex Law and Zubri has helped to clear the way, then there's definitely there's definitely a pent-up sort of desire to try and get these moving along, and I think that's good. Unlike fixed recoverable costs. Now I know you didn't come to me on fixed recoverable costs because I use rude words, but so I'm not going to do that. And but so no, DBA is good, fixed recoverable cost bad. That's my in-depth nuanced comment on it.
Entirely free of self-interest as well.
None whatsoever, I'm pleased to say, as ever, none whatsoever. Well, I mean, I could be, I don't know, I suppose I could be snobby and say, well, we don't do a lot of cases, our firm don't do a lot of cases, but if that doesn't mean to say that I don't care about, other people and the world in general. I absolutely do. And, what's more, if they all catch a bad cold about it, then we will too. That's the way the world works.
That's been in the fear in the past, hasn't it, from the introduction of fixed recoverable costs way back.
Exactly. Anyway, you don't want to hear me talking about the analogy with discretion to exceed county court scale 1. So move on.
Let's talk about the exciting topic of pre-action protocols instead. Then, Roger, as I said, there has been this new CJC interim report. A quick word on that.
Yes, I mean, I think the consultation is still open, isn't it? It closes.
Yes.
Christmas Eve, I think it closes, doesn't it? For those of us who've got nothing better to do on Christmas Eve than respond to a consultation on pre-action protocols. Nice way to build up to Christmas. Yes, I mean, there didn't seem to be a great deal of sort of flesh on the bones at the moment, really, for us to talk about in terms of costs. I see that there's a proposal, obviously more online. We're all going high tech, everything. I think they quite like the way the online portals mostly have been working for things like the low value RTA and EL and PL cases. And so I think there's an idea of a significantly greater use of sort of online portals for pre-action work. From a cost perspective, I saw, I mean, you guys may know a bit more about it than me, but I saw there was talk of a new summary costs procedure for pre-action settlement cases, which interestingly enough mentioned not just dealing with quantum disputes, but costs liability disputes, which sounded interesting, but I don't know quite what's meant by that, but it sounds like one maybe to keep an eye on for the future.
It's quite hard to see how you can have liability disputes other than under the existing schemes, if you like. But it's hard to think of new ground there without changing the law somehow.
Yeah.
I noticed one thing that one of the proposals is there'll be a formal stock take with joint lists of issues 14 days after the conclusion of the good faith steps, as they're called in the recommendations. I just see more costs and more front loading there, but is that a cynical view?
From my point of view, no. I mean, I agree. It did sound as though the whole process is going to become much more formal and regimented if that's followed through with specific, as you say, specific steps. And how are people going to do that unless they're incurring costs to do it?
Yeah.
So.
And it will generate arguments as to, well, what is and what isn't agreed, or what is an issue and what isn't an issue, and all that sort of thing. And they've attached a form as sort of draft proposal form for this list of issues, but it seems to me that it's going to go way beyond that and really be quite a complex process potentially.
Yeah, and of course you'll then also have arguments about compliance. You know, have people properly complied with all of these new requirements? And again, from our perspective as people interested in costs, then, you know, cost sanctions, presumably to try and make this effective, there'll be cost sanctions built into this. If you don't tick the right boxes at the right time. And so you'll then have a string of cost arguments flowing from that about what sanctions do and don't apply.
And more trips to the Court of Appeal for cost silks arguing about £100 or something like that, because they were so much. Not
something I would ever encourage, of course.
Andy, I can't bypass you again after the last objection. Any views on any of this?
No, I think I like us being bang up to date with talking about ideas for consultation that have come out about pre-action protocols. But I utilise the same arguments everybody else does about in terms of people not following pre-action protocols and what horrible things that should happen to them if they haven't, and the opposite if we're on the opposite side. And as an exercise in good practice, I think they are the right sort of guidelines, but I don't think that they should turn into too much of a stick to beat people with, to be quite honest, because it's so fact sensitive in terms of the attitude of the protagonists in a fight that's looming. And I don't like pre-action protocols weaponised any more than I like compulsory ADR weaponised. And it is, and I find that element a bit dull as well. When people look to get involved with the cost building exercise for interim ADR that you all know in the certain circumstances of a case is not going to solve it. You know, really that's what courts are for, aren't they? To settle disputes between people. A terribly old-fashioned view, but
pre-Wolf, I think.
But you know, but it sort of ignores. It seems to ignore, you know, our daily experience in practice, which is that the law firms we work for and their clients, well, certainly the law firms we work for, work incredibly hard to try and distill the issues and try and get rid of cases and try and settle things and try not to go the whole way. And most cases don't go the whole way and they don't go to trial and they do settle early. And it's the same with detailed assessment as well. So it's like a lot of these things in terms of it's even expanding it back to whether budgeting is working. Well, clearly budgeting does probably add to aspects of detailed assessment if it goes all the way, but it ignores the hundreds and thousands of cases that don't go to detailed assessment because they were budgeted. Amongst other things. And it's the same with pre-action protocol. You know, when it works, it must be great. And guess what? The courts don't see them.
Well, if I can bring it, actually, Andy, to because of course, what certainly from my perspective, what we tend to see is the stuff that fights, the stuff where there is a problem. And if that's your experience, particularly budgeting, that, you know, it's having a real effect because things just aren't being contentious because they have been budgeted. That's really interesting to hear. Well, I mean, I think it's more that I suppose that there's a smarter argument these days in a budgeted case that lends itself to a form of ADR by negotiation or even mediation of if there's an overrun on budget and isn't there always. By how much, as opposed to let's throw it away and, you know, do everything line by line and forget that budgeting ever happened. You know, the type of argument. Yeah, there's a structure to it, and you know, let's have a look at the drivers to budget overrun and what effect would that really have on a case. And it, you know, in my experience, it helps in those situations. That's me. So and ADR, you know, is the same issue, but. Sorry, not ADR, pre-action protocol, the same issue, but earlier. I mean, I have a lot of our instructions these days are almost to try and work out a pre-action protocol that doesn't exist for detailed assessment.
how do we put forward details of people's costs to the other side in such a way that it will actually mean something to them, that falls short of a full bill, that we can have some sort of sensible, informed negotiation about? And what would that look like? And what would that cost, as opposed to trench warfare leading to detailed assessment in 15 months' time or something like that? And that's our world most of the time, I have to say.
Should that in itself be the subject of a recommendation on pre-action protocols, the cost procedure?
I used to think yes, I now think no. I just think that's how I think it's the best way forward, but I wouldn't necessarily want it to fall down the route of having to follow a particular structure and tick boxes.
Happier to work it out among yourselves, like among the cost lawyers.
Absolutely, yeah. Absolutely.
It is obviously it's a much smaller group than solicitors as a whole, so in a sense, that's got a drive behind it, which probably helps.
Yeah, no, exactly. I mean, it's really it's a small question that's got a big complicated answer, which is if you're going to produce a schedule instead of a bill, what level of particularity should it have, and how useful is it?
Yeah.
Well, if you want to, just having a pre-action it would be just I think about as popular as Solicitors Act reform leadership to say, let's suggest a pre-action protocol for detailed assessment, and so I'm not going to do that, but we have it in mind in terms of how we go about things.
Yeah. The idea is out there now, Andy. That's the danger. Once these things are voiced, before you know it, they're getting a life of their own.
Yeah, exactly. Yes. Well, give it another 5 years, maybe.
If you want an international perspective on all of this, on all these things we've been talking about, basically, which are reform of the civil justice system, Italy has just been given a shed load of money by the European Union on a number of conditions, one of which is that it tidies up its civil justice system. The average time for a civil case to be resolved in Italy is 7.5 years. And with all the reforms in place, they're hoping that it will get down to 5 years. So if that gives, puts it all in perspective, because that actually takes me back to pre-Wolf days, when the times for civil litigation were of Italian proportions, I think it's fair to say, in many cases. So whatever view you take, if you like, of Wolf and Jackson, all the things that have followed, it certainly has made a massive difference, and I think we should be grateful for that. Finally, then, I don't know if it's a lighter note or not, but we've discussed in our various online talks over the last couple of years the effect of the pandemic and the way in which the courts were coping with it, the way in which the costs office is coping with it, and the way in which practitioners are coping with it. Do we feel there is an opening up now? Do we feel that there's a possibility of a return to more actual hearings as opposed to a lot of stuff being online? What's the view in the profession there?
Well, I'd be interested to hear what Andy says, because obviously he'll have a sort of slightly wider view and see probably a greater number of cases. From my point of view, I thought we were heading towards an opening up. I had quite a few hearings in my diary from October onwards, which said this will be an in-person hearing. And in practice, as they've got closer and closer, they've nearly all reverted back to being video hearings. And I suspect, given what's happened over the weekend and given the way things seem to be heading, probably in the next few weeks as we build up to Christmas, I suspect that's going to continue. So I have got a couple of in-person hearings in principle between now and Christmas. I'll be interested to see if they stay like that. But I think the general feeling coming off the back of the summer that we were going to be looking in the latter part of this year to things getting back to normal doesn't, in practice, from my point of view, seem to be happening. It still seems to be mostly video hearings, mostly remote meetings, and I suspect that's going to continue into the new year.
And I mean, the cancellation of those hearings obviously predates any concern about the South African Omicron variant. So is it your view possibly that people are really rather attached to the way they've been working over the last couple of years and will keep it going beyond pandemic times, if you like, or beyond serious pandemic time?
Well, I think there've been some good aspects of it. I mean, certainly when it comes to things like conferences and things of that kind, I think it's made life much easier, particularly when you've got overseas clients and matters of that kind. And when it comes to hearings, my general experience is that some judges seem to like video hearings for some things, some don't. And obviously it seems to me there is a continuing place for some of these things. There are some hearings which suit video hearings much better. From my experience, actually, I think appeals tend to work quite well as video hearings. Still not quite the same as standing there in front of the three judges and being tag teamed and torn to pieces in person, but they can still do a pretty effective job of that over a video. And you have a well paginated, well prepared single bundle that everybody's got. There's no handing up of papers, there's no cross-examination. Those sort of things, in my experience, tend to work quite well by video, and I wouldn't have a problem with that carrying on. Other hearings, and I'll be interested to hear what Andy has to say, particularly detailed assessments. I think that thing of being in the room and having the papers there, and also the sort of the things that ease the process, the little chats in the corridors with your opponent before you go in, and the hitting on a point halfway through a hearing and saying to the judge, can we just have 5 minutes outside for a quick chat? Those things are much more difficult to achieve, I think, by video.
Andy?
Yes, I agree with that. Our experience in lockdown is a sort of game of two halves. I think most of the first year, the 2020 year of it, was everybody being exceptionally well disposed towards trying to make everything work and make it the best of it. And there's a novelty aspect to it, and pleasant surprises about how well they worked in terms of hearings, even detailed assessments, which are actually quite tiring in a strange way compared to in person, but effective, and they work. And then the the 2021 lockdowns, and even until people started coming out of them, just found it to be a drag, and missing those little bits of glue that Roger's talking about, in terms of the bits you can do in between and on during short adjournments and before and just after, with opponents, professional colleagues that you may bump into in the corridors, etc. Little chats with the cost judge afterwards about some other matter or a general point or something, which I really miss. And I mean, I think the example that I'd give actually is, outside of hearings, because of the pandemic, we actually hadn't met as a firm all together in person, face to face, from August 2020 through to about 3 weeks ago. And we had it 3 weeks ago, and we had a sort of like a formal meeting where we all got together in an office and did stuff for 2 hours, followed by a lunch. And it's only when you do it again that you realize how much you miss it, and how much you and what you have been missing. And having then broken the ice and done it, you want to do it again, and so I can see a return to some form of normality / hybrid arrangement, with more face-to-face, more meetings with colleagues, more in-person hearings. But it's so fragile. I mean, I think we would have had a hugely different conversation about this in the middle of last week,
Yeah.
Before the South Africa variant comes along. And the minute it comes along, despite the fact that I was feeling, speaking personally, I was feeling, well, perhaps we are seeing the end of this, having a booster jab 3 weeks ago sort of stuff. So, I feel top protected, in the sense that, and then this thing comes along, you think, oh, Christ, we're back to square one again. It's just horrible. And also, it's not really a point for this session, but I'll say it anyway. Going off on the tubes is absolutely distressing in terms of the amount of people that, willfully don't have a mask on, and it's almost like they're eyeing the carriage, to sort of, to try and say, come on, call me out then, I want the route, it's not a nice experience.
Yeah. You said after your recent, the first meeting 3 weeks ago, you could do with more of this. But do you think on a long-term basis, more of it, but not exclusively that? So a bit more, but still a lot of home working, a lot of
yes.
distance hearings, etc., etc.
Yeah, absolutely. Absolutely. I mean, it does seem to be in slightly poor taste, so we have to caveat it to say, the good things that have come out of the pandemic. But the acceleration towards working paperless and e-bundles, we'd be waiting forever for it if it hadn't been for this. And that won't go. I can't see how that's ever going to go back, and nor should it.
I think that's been a massive difference from my point of view. Just the paper has gone.
Yeah.
I'm sure we all know we used to spend our lives in rooms where, one of my colleagues in Chambers, quite literally in his room, he had effectively internal walls built in it with boxes, and it was like a maze working your way through to try and get to his desk. And it has completely gone. I think I've had maybe 2 boxes of papers delivered in the course of the last 2 years. Everything is digital, and it makes a huge difference.
Yeah. Yes, it does. I mean, it's not. I've got to say, I don't find it that easy to manage. But then again, I didn't find masses of boxes of papers that easy to manage either. So it's just different, and broadly it's better. And we're again back to the dreaded, front loading, and it is. But it will get better, and it must be persevered with. But preparing electronic bundles for detailed assessment hearings is a big job. You really benefit from doing it, from it. But let's be under no illusion, it takes a long time.
Yeah. Well, on that note, which is partly down and partly up, I think generally up. Actually, I think the fact that has been this sea change in handling of documents as a result of the pandemic is definitely an up. And on that note, I think we'll leave you. There won't be another of these, I think, before Christmas. But so wish all those who are watching a very happy Christmas and New Year. And we'll sign off with many thanks to Roger for joining us with his insights into these matters.
Thanks, Roger.